Okay, so now we are at the question time. We've got 19 questions that have been submitted, so we're going to step right in and start answering questions. So first question, are reserve studies for condominium associations a legal requirement? So by legal requirement, I'm going to assume that you mean like, is it required by Arizona law? No. Reserve studies are not required by Arizona law. You may have a requirement in your association's documents, although I doubt it, but it's a possibility, so you may want to check. Just so you know, Arizona law does require that associations disclose to buyers the amount of money in the reserve, and also disclose a copy of the reserve study or a summary of the reserve study if it's over 10 pages to a buyer. So you have some disclosure requirements of how much money you have in your reserve and to give them a copy of the reserve study if you have one done. But there's actually no legal requirement under Arizona to mandate that you have a reserve study done. But that being said, it's a really good idea for planning purposes, for the maintenance and, capital improvement replacement to have a reserve study for your association. Okay, next question. What are the pros and cons of enacting a capital improvement fee for buyers of homes in our HOA? So we actually have a great cheat sheet on this called transfer fees and disclosure fees. A capital improvement fee is kind of another name for like a transfer fee. Sometimes the transfer fee is used for long-term capital improvements. But why is a capital improvement fee a good idea? Well, it's just so everybody's on the same page. It's a fee that's typically paid by a buyer. It's like a buy-in fee when they purchase a lot or unit in the association. And it can be anywhere from a percentage of the sales price to a flat dollar amount. And it's all outlined in the CC&Rs. So there's a specific statute in Arizona that requires if you're going to charge a capital improvement fee, it needs to be in your CC&Rs, and you have to meet the specific criteria of that statute. And that's all on our cheat sheet on disclosure fees and transfer fees, which my office has already shared with you right now in the chat. So pros are it helps fund your reserve, and it is a mechanism to get income into your association. I'd say probably 75 to 80% of associations are doing this as a mechanism to fund your reserve so that you can continue to make improvements and upgrades and replacements in your association. It's very common. Some cons on it are, and another pro, I guess I would say, is that the current owners aren't paying in. It's the new owners who are coming in are paying in. Some cons are that it's probably not fair in some cases that the new owners are getting stuck with having to pay, large amounts to buy into the association. Some people think that's not fair. I think if you're setting the capital improvement fee or the transfer fee at a reasonable rate, I think you can overcome that argument that's a con. And because it's so prevalent now, there's not that many associations that don't do it, but the con could potentially be that, hey, someone's not going to buy my property in this association because of this capital improvement fee. Although I can tell you with working with over 1,000 associations, I've never seen a sale go bad because of that. I think a con is that maybe we're pushing too much on the new owner, and maybe the current owners should be paying a little bit more to fund the reserves because they've been living there the longest. But overall, my feeling on capital improvement fees are that they're a good idea as long as they're set at a reasonable rate. Question 3, regarding short-term vacation rentals. I've read somewhere that the owner of a vacation rental must notify their neighbors of the names of their renters and license. Is this true? How do we, the HOA board, know if they have liability insurance? So great question. At the beginning of my presentation today, we talked about the new law that's going into effect on September 24th, and we have a cheat sheet that we also shared with you on the new law. And the bottom line is that the city or town is responsible for, keeping track of all of these special requirements starting September 24th. And so, having the emergency contact information, the city or town is going to have to do that. Getting the permit, the owner is going to have to get that with the city or town. that the owner must notify all the single-family residential properties adjacent to, directly and diagonally across the street from the property. The owner's probably going to have to, sign some sort of a verification with the city or town. And displaying the permit on the advertisement, that's going to be something that's an onerous on the owner landlord, and the city is going to be responsible for enforcing it. Same thing on the insurance. And so the association's role is really kind of minimal on that, because the city is going to be the one that is responsible for making sure it's done. I suppose that, one thing the board can do is make a public records request to the city or town to make sure that owners are doing it. That would be something that you could do. Requiring the owner to give you this information, I don't think you can, because the statute in Arizona is very specific on the type of things that we can ask the owner to provide to us. And it's limited to just the names of the adults residing in the property, the vehicle descriptions of, the cars that they drive and their license plate numbers, and, how long the tenancy is going to be. That's it. We can't ask for anything other than that. So, we're going to have to kind of backdoor it and go to the city or town to find out that information. Next question. If an owner lives in the house and also has family living with them, does that affect with the new legislation? I'm assuming you're talking about the new legislation regarding short-term rentals, and if there's no money being exchanged with the family that's living with them, probably does not affect this. Question 5. Some associations in out-of-state have restrictions on rentals to include caps, like a percentage of units that are allowed to be rented. Ownership, such as an owner cannot rent until the owner has occupied for a certain number of years. Is this possible in Arizona? Yes, an association could write a CC&R amendment to include this information if they so choose. That's something that can be done. Now, on the percentage of units allowable to be rented, our firm typically doesn't recommend that, because it's really hard to determine who should be in that percentage. And if somebody doesn't win the lottery to rent that year, they potentially could sue the board. It's just complicated. Also having like a time period, that they have to own before they can rent, that can be put in the CC&Rs. I have seen some associations starting to do that. But again, that would need to be done in a CC&R amendment. Question 6, is there a timeline date on the increase to the HOA members? So I'm wondering, is there a timeline date? So I'm guessing the question, maybe just to reframe it, is, so if you're going to have an increase to the assessment rate, how much notice should you give to the HOA members? Well, as a starting point, look at your documents, your CC&Rs. It may say something in there about, a timeline that you'd have to give. It's kind of unusual provision, but it could be in there. I would say from a practical standpoint, there's no legislation on this, just so you know. From a practical standpoint, I would say giving owners at least 30 to 60 days notice of an increase seems reasonable to me. That would be what I would recommend, but ultimately there is no requirement. But if you want people to comply, obviously, and pay the higher correct rate, you're going to want to give them plenty of notice. Okay, number 7, do any of these legislative changes help out those of us as private condo owners who live under the management of declarant? Thank you for your constant work on behalf of condo owners. Well, that's really nice. Thank you for saying that. Okay, so do these legislative changes help us under the management of the declarant? Probably no. None of the legislative changes that I talked about here today, really are, I'm not sure what you mean by help who live under the management of the declarant, but in some cases we're hearing that the declarant, when they're in control of your board, they're not giving owners a lot of rights, and they're not, sharing information and having board meetings. And so it's always a really difficult time for owners that are, living under, let's say, a declarant regime that's running the board. Not always. There's some declarants that are awesome, and they are developing large master plan communities, and they are doing a great job of communicating and having owners be involved. And the only reason why they're still the declarant is because they're just finishing up the development of the community. And as soon as the opportunity comes, they're going to move on to their next development and have a smooth transition to, whoever the new board is. But sometimes you do have bad situations with declarants. Unfortunately, none of the legislative changes that we talked about today are going to help you with that situation. You may want to take a look at, we have a cheat sheet on transition from declarant to homeowner control that may give you some tips on where to look in your CC&Rs to determine when that transition needs to take place and what are the common issues as a helpful starting point. You may also want to just reach out and talk to your declarant and say, hey, we want to get more involved. We need more communication from the declarant. How can we improve our relationship between the homeowners and the declarant while you're still in control? Question number 8, where should prepaid dues show in your monthly financials? What is best, cash versus accrual? Oh, that's a tough one. Okay, so where should the prepaid dues show in your monthly financials? Sometimes there's a separate line item for that. Sometimes it's just lumped in with your, on your income statement. It's just lumped in as already being there. If it's lumped in with the, the regular assessments that aren't prepaid, it can show a false sense of security in terms of, you may have other owners who aren't paying, and prepaid owners not having a separate line item makes it look like you are fine in terms of the income that's coming in. But really, when you get closer to like November and December, you're going to start to get a real scary reality that those prepaid dues are whittling down. And now you're realizing that, hey, 10% of our owners aren't paying their dues and we don't have enough money for December. So I think it's best to have them on a separate line item on your budget and also on your financials if you're able to do that. What's best, cash versus accrual? Talk to your CPA. I don't really have an opinion on that. I know that associations use both. I'm not a CPA, so it's hard for me to, give you my opinion on that. And that would be my recommendation. Okay, question 9. Can we subtract late fees from the HOA dues when a resident makes an HOA payment, or do we keep a separate tally for HOA dues and late fees? Okay, so let's see. Can we subtract late fees from the HOA dues? So the only time that you can charge a late fee is you need to look at the documents, of course, for your association. You also need to look at state law. So if you are a planned community, you can charge a late fee once the assessment is 15 days past due. And it's the, it can either be 10% of the assessment or $15, whatever is greater. So that's how you can charge, the late fee in a planned community. In a condominium, you're allowed to charge a late fee. It doesn't, give a time period that you can charge it after it's past due or an amount. So you want to check your documents for that. Do we keep a separate tally for HOA dues and late fees? I would keep a separate, line item on your income and your budget in terms of what revenue you're receiving from late fees. So you can keep track of it. Next question from an owner. Our HOA has recorded CC&Rs and a plot plan with the Maricopa County Recorder's Office. The association membership recently adopted a restated and amended set of bylaws. It is my understanding there is no statutory requirement language in the bylaws be recorded at any official level. Would you consider, suggest, or recommend that the bylaws be recorded with the Maricopa County Recorder's Office? Should a printed copy of this governing document be provided to all property owners within the development? So short answer, bylaws are never recorded with the County Recorder's Office. That is not something that is done. It's confusing if you do it. So we would recommend not doing that. We would, however, recommend that a copy of the bylaws be on your association's website or provided to all owners if they request to see a copy of it, or if they're changed, you have to provide the updated bylaws to all owners. Next question, number 11. If an HOA has a large ongoing capital project, but due to budgetary restrictions needs to do the project in phases, Have you ever heard of HOAs getting loans to complete the project more quickly? What are your thoughts on this practice? I have a resident that insists that we do this, but as treasurer, I feel that it's a terrible idea. Okay, so we do have associations, or I have represented associations that have obtained loans over the past 25 years. Typically, the loans are done at the beginning of the project to help supplement any increases that the association, may be making to do the project, or maybe the association can't afford to have an increase in assessments, or maybe the owners refuse to vote for an increase in the assessments or a special assessment. So there's a number of different reasons why you take out a loan. I mean, obviously you're paying interest on the loan. You're collateralizing your assessment income. So there's, a level of danger on that. I've never had an association default on a loan, and these are pretty regularly done in our industry, so that you know that. So is it a terrible idea? I don't think it is necessarily. I think for some associations that have no other choices, it's an avenue to, continue to do capital improvements in your association, or things that really need to be done that you can't afford because of poor planning in the past. Switching to get a loan to complete a project that's already underway, I'm not even sure the bank will do that, but you might want to reach out to a couple banks. If you need some names of banks, reach out to me at Beth Mulcahy at mulcahylawfirm.com, and I can point you in the right direction on that. And usually these are larger loans, like $1 million, $500,000, $1 million. So I don't know the numbers that you're looking at here, but I just wanted to mention that. Okay, can homeowners see the financials that the board members see? Yes, absolutely. Homeowners just need to make a written request to the board that they want to review the financials, and that is sufficient. They should provide the financials to you within 10 business days. Now, can you see it at the same real time that the board is seeing it? Probably not, because at the board meeting, the board is reviewing it, and if there's any changes or anything that needs to be made, they'll be made after the board meeting. So once the financials are approved, then you can make the request to see the financials. Next question, how many board members should represent a neighborhood of 15 homes or lots? So it just depends. I mean, if you're a smaller association, maybe 3, maybe 5, but really your bylaws dictate the number of board members traditionally, or possibly your CC&Rs or your articles. Next question, 14, what if none of the board members want to be a treasurer and the position remains unfilled? That's problematic, because I'm sure your documents require that you have a treasurer in your bylaws. Try to get somebody to step up. Maybe you have the president serve also as a treasurer, although that's a big responsibility for the president because they already have a lot of presidential responsibilities, but it's not a good idea. So what should you do? Try to pressure somebody to be the treasurer, and maybe divide up the responsibilities so that everybody takes a portion of the responsibility of being the treasurer. Next question, number 15. What does 80% of the reserve fund mean? How do you determine it? So 80% of the reserve fund. Okay, so basically you have a reserve study. Most associations hire an independent qualified reserve specialist company to come in and prepare a reserve study for you. And the reserve study outlines what your, different amenities are for your association, and which are capital improvements, and the useful life of them, and how much money you will need each year to replace or repair things over a 30-year period. And so 80% of the reserve fund, like some people say, it's just kind of like a slang that's used that says, okay, most associations don't have their reserve funded at 100%. That's not common. So most people say kind of a safe zone for reserve funds is somewhere between 60 and 80%, where if you have that 60 to 80% of your reserve fund, you're probably in a safe area, where financially you're safe. Now, of course, as your attorney, and how do you determine it? You just take the number that your reserve specialist company tells you should have in your account, And they'll tell you the percentage, it's actually on the reserve study, what percent you're funded right now. And each year you're trying to attain 100%. But you can look at the number that they say you should have in your account right now, your reserve account, and then you can look at what you have, and then you can figure out the percentage that you're funded. Okay, next question. I see our HOA heading towards a special assessment for replacement of our roads. Our CC&Rs do not have a special road replacement fund. The homeowners voted in an assessment increase that was specified as being for the roads, but the board doesn't seem to understand that more than just the money obtained from the increase needs to be set aside. We need to increase the total of the annual set aside. They're spending the money elsewhere. I think most of our homeowners will be very surprised when a special assessment comes down for the roads. What should be done? Okay, so I guess I'd have to look at, the prior assessment increase, that was specified for the roads. I don't know if it was a special assessment or maybe if a portion of the regular assessment was used for the roads. Roads are expensive. It's the board ultimately determines how, the association's funds are spent. But if they, say that a certain amount is being used for the roads and then they don't use it for the roads, I think, that's problematic, equally problematic. But sometimes circumstances dictate that, hey, there's an emergency. We have to take some of that money, that we had allocated for the roads and now, replace the front gate because it doesn't open anymore. So there are different things that can come up. So I would encourage them to talk with their attorney about how the funds have been used and maybe have a full disclosure to the owners. And if you need to have a special assessment in the future for roads, that you maybe set that up in a separate account so that the money is segregated and not used for other things. Okay, we have just a few more questions. I'm on question 17 and we have 21 questions. 17, does contacting the Department of Real Estate when the board president and treasurer won't address a serious problem do more harm than good for the HOA? So what you're referring to is the Arizona Department of Real Estate has an administrative law procedure that members and board and associations can use to resolve disputes. They have to be a disagreement or a dispute regarding the association's documents or state law pertaining to associations. And so going to the Department of Real Estate, when you feel that the treasurer isn't using or the association's president and treasurer aren't addressing a problem, does it do more harm, or good for the HOA? It's hard for me to comment on it. What I can tell you is that you'll get their attention if you file a complaint with the Department of Real Estate. If it's one claim, you're going to have to pay a $500 filing fee to have the matter heard by an administrative law judge. The administrative law judges that hear these cases are amazing. They do a wonderful job, and it's a quick, fast, and easy way to get an answer if there is a problem at the association. Now, that being said, because my practice focuses on representing associations, what I would encourage you to do is reach out to your board and let them know that you're thinking about going to the Department of Real Estate to make a complaint on this issue, and you're hoping that they will come to the table and talk with you about it so that you don't have to do that. Give them one final chance so that hopefully they can resolve it with you informally. Next question, number 18. At my last board meeting, I questioned why 2 purchases or I-series bonds for $10,000 each were not listed on our balance sheet. 2 weeks later, there is no explanation for this anomaly on our financial statements. What do I do next? I would ask for a copy of any evidence of these bonds, like do they exist? I'd also ask for copies of your bank statements so that you can cross-check it and your balance sheet and your year-to-date budgets. You can cross-check to make sure that what they're reporting to you, you actually see the written proof for it. Okay, next question, number 19. Please tell me if you think an HOA can require a certain brand of paint be used on the buildings. I do understand that they can require certain colors, but a brand. Okay, so what we are seeing a lot is there's different companies that will come out and do a paint evaluation for associations free of charge. And it's typically when the association is updating their paint colors and their paint palettes. And it's actually a really great service because we want associations to stay with the times. And maybe Navajo white was in the early 90s and late 80s, but now we're going to more earth tones and warmer colors and tans and creams or whatever. And so, it depends. If your association's documents allow the board to, come up with approved paint colors, or if you have a broad rulemaking authority on paint colors, your board certainly has the right to, demand that you use, a certain brand of paint. But I think also you can match the paint colors. And so you may want to talk with them about, hey, I want to go with, a different brand and we're going to match the paint color. Are you okay with that? Recognize that certain paints brands have a longer longevity. So you might be taking the risk of having a lower quality paint that you're using, even though you are matching the color. But I would talk about it with the board. Don't just do it, because I've had a lot of paint cases over the years and they're problematic and they're expensive. And, it usually results in someone having to repaint their house. And I don't want that to happen to you. Next question, 21 or 20. When can a reserve fund be used? Our community needs much work needed above our budget. There's plenty of funds. Why are we not allowed to use them? Well, reserve funds are used, just for reserve items, so capital improvement items. And so you can't use, the reserve fund to, maybe do like some general maintenance work that's not covered under the reserve. And so, you want to be careful. Those funds are allocated for long-term capital improvement projects in the association. And so, you can't be robbing Peter to pay Paul. So those are allocated already. Occasionally we'll see a board, because they have no other choice, use reserve funds for non-reserve items. You have to talk with your CPA because you usually have to pay that back in the same calendar year. So I'm just mentioning that to you, that's something that could be, problematic. And it's really not advisable. What you really should be doing is looking at increasing your regular assessment rate to handle the non-reserve items. Okay, next question. How do you handle accounts where the owners don't pay late fees? They pay assessments late, but they don't ever remit payments for the late fees that have been accrued. Okay, so you want to make sure that the owners understand that the late fees we can lien for as well. And so if they don't pay the late fees, we can put a lien on their property. We can file a lawsuit against them for the unpaid late fees. So you just have to take actions to collect on it so that they know that these are things that you can't blow off and there are legal consequences if you don't pay. Okay, last two questions. Should homeowners receive a copy of the board packet for board meetings as well, or should they just be receiving the financial statement and the agenda? So should homeowners receive the board packet for board meetings? It's uncustomary that homeowners get the board packet. Because the board packet typically contains items that they're not allowed to see, such as, like the delinquency list and, maybe issues, legal opinions and things that, wouldn't be something that you're allowed to see. What you could do is ask for a copy after the meeting of the board packet with any items that, are not withheld under the law. So you could ask for that if you wanted that. But typically at a board meeting, you're only going to be receiving the financial statements and the agenda. Remember, the agenda we're required to provide to all owners at the meeting. The board is. The financial statements we're not required to, but it's just a good idea because it's their money too. They're homeowners, and it's important if you're talking about it that they can follow along. Last question. Why does the percentage funded requirement for reserve funds decrease over the period of the reserve fund period? If money is paid out for a cyclical expense such as painting, doesn't the reserve fund need to be replenished? Okay, really good question. So what happens is if you looked at a lot of reserve studies like I have over time, there's a fluctuation in terms of, the reserve. So there'll be different times where you're in rebuilding years And then there'll be different times where you're in spending years, and sometimes they cross over and sometimes they don't. So typically when an association gets a reserve study done for the first time, or they're updating it, they're going to be showing a deficit, like the percentage funded is going to be lower. And then over time, like my association, when we were recovering from the embezzlement, we were really, we were like down at like 4% funded or something really low like that. Now we're up to like 70 or 80% funded. So, there's going to be years where you're rebuilding, and then you're going to have a big expense. You got to redo the clubhouse or something, and then it goes from 80 or 90% funded, and then you go down to 40% funded, and then you just have to step it up and rebuild it. So that's pretty normal. Having it be immediately replenished when you do a big expenditure like roads or repainting, it's just not typically possible unless your association's willing to do a special assessment to fund the reserve. And most associations don't like doing that because it's not a real popular decision when people have to write like a $5,000 check just for the money to sit in the reserve to replenish the funds. So most associations, don't handle it that way. Most associations will take money every year from the assessment income and put away money every month into the reserve to continue to rebuild it. Now, if it's at an artificially low number, and your percentage, you got to get out of the under 10% or under 30% or whatever you're at, you may have to do a special assessment to fund it. Okay, so that's it. So we had a great class today. Thank you so much for being here. At one point, I think we had almost 150 people joining us live. I'm so sorry for the audio and technical difficulties we had at the beginning of today's session. I hate it when that happens, but I appreciate your patience, kindness, and encouraging words, because we were getting a little hot under the collar here, worrying about things. But Morgan, who is my superstar, Morgan Ronimus, was always cool under pressure. We switched out the computers and we got back online really quickly. So for those of you, we will be sharing with all of you our cheat sheets and also our script for today so that you can take a look at it. If you have any questions or you missed anything, thank you again for joining us today for class number 8 of our Virtual HOA Academy, our 2020 Virtual HOA Academy. It has been awesome to partner with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Really for over the past 2.5 years since the pandemic started, to give you live virtual presentations where we can provide information to you on a variety of topics and have a time period where we can stay and answer your questions for free, so that you feel that you are not only able to listen in on a presentation, but then also get immediate feedback to your questions. So this format has just been working really well, and we appreciate the large volume of people who are taking advantage of it. A few things to mention as we look forward to our busy month of September. We have several free learning opportunities. We have our first Friday free call-in, and that is going to be Friday, September 2nd at 9:00 a.m. It's our firm's monthly virtual First Friday free call-in, where I answer your HOA and condo legal questions live. You can always find additional details on our First Fridays or any other seminars that we're teaching on our firm's website at mulcahylawfirm.com. You can submit questions that we will answer live on September 2nd, starting now, through the morning of September 2nd at 8:45 a.m. So be sure to tune in for that. We usually get a lot of great questions, somewhere between 30 and 50 every month, and we answer every question. Also wanted to let you know, Chandler residents, any of you who are listening in today from Chandler, on Tuesday, September 13th at 5:00 p.m., I'm going to be in person at the City of Chandler for their HOA roundtable, where we are going to be discussing hot topics for HOAs and condos. Please visit our website for more information on this event. And again, our website is mulcahylawfirm.com. And last but not least, we have our 9th class for Neighborhood Services Virtual HOA Academy on Thursday, September 14th I have another class I'm getting a little tripped up here on September 14th. So I'm going double duty that week, September 13th and 14th. I'm going to be teaching for the city of Scottsdale for their fall 2022 Scottsdale Neighborhood College. And we're going to be talking more in depth about the new laws that are going into effect on September 24th. And we're also going to cover our most popular topic, which is what are the roles and responsibilities of board members. And last but not least, on September 20th at 11 a.m., we're going to have class number 9 of our Neighborhood Services Virtual HOA Academy. That's going to be on Zoom and Facebook Live, just like we always do it, the third Tuesday of the month at 11 a.m. And we're going to be talking about rental restrictions and amending CC&Rs. And you can bet sure as I'm sitting here right now, we're going to be talking about the new legislation because that is definitely going to impact how we handle rental restrictions in associations. So September is shaping up to be a very busy month. It's back to school for my kids and also back to teaching a lot of classes for our industry, which I absolutely love doing. So look forward to seeing all of you with our 4 different teaching opportunities throughout the month of September. Again, if you want any information on them, you can go to our website at mulcahylawfirm.com. Thanks again, everybody, for being here today. Sorry again for some of the technical difficulties and look forward to seeing you in September. Take care.